It is an amendment to this bill. This bill, as amended in the Senate, originally moved violation possession of less than an ounce of marijuana down to a B violation, which changed the fine because statutorily the fine is set at $650. This created a negative revenue impact of around $2 million to change the fine from presumptive from $650 to down to $250. So there is an amendment right now that's A3, which would put that fine back at $650 just as it is today.
Gail Meyer and Peter Kramer.
Thank you. Chair Barker, members of the committee, Gail Meyer on behalf of the Oregon Criminal Defense Lawyers Association. As originally introduced, Senate Bill 40 was a very simple bill. It was just a technical fix of aligning the classification level of marijuana with its status as a Schedule II drug. Over on the Senate side, though, it became a vehicle for a bigger policy shift by way of making a misdemeanor possession crime. And so I'll go through those changes, but the good news is that if the amendment is adopted that Mr. Schmidt pointed to, then there will be immediate cost savings by these recalibrations of $2.43 million in the current biennium, and in the 2015-17 biennium, cost savings of $3.88 million. So, as to the first change, which would simply be the technical fix, what happened was, it used to be that marijuana was a Schedule I controlled substance, and subsequently now it's a Schedule II controlled substance, but our crimes in our statutes still reflect the old calibration of marijuana as a Schedule I drug. So Schedule I drugs have as their manufacturer, for manufacturing and distributing, they're an A felony and possession is a B felony. For Schedule II drugs, manufacturing and delivery is a B felony and possession is a C felony. So what happened in 2009, the legislature directed the Board of Pharmacy to reclassify marijuana as something other than a Schedule I drug. And in 2009, the legislature didn't know what level the Board of Pharmacy would choose, 2, 3, 4, 5. So subsequently then to session, the Board of Pharmacy decided we will reschedule marijuana from a Schedule I drug down to a Schedule II, and that's what it is today. But the legislature's never caught up and cleaned up the criminal statutes to calibrate the crimes of marijuana manufacture, delivery, or possession to reflect that Schedule II status. So that's what the technical fix does. Then, as I say, over on the Senate side, there was interest in using this bill as a vehicle for another policy shift, which would create a misdemeanor possession crime. As our statutes currently read, possession of less than an ounce of marijuana is a violation. Possession of more than an ounce of marijuana is a B felony. That is the biggest leap from one crime to the next in the entirety of our criminal code. So with the technical fix, possession would be a C felony, but even that, to go from a violation to a C felony is still a pretty big jump. So there was a combined effort that was driven really by Senator Cruz and Senator Przonski to create a misdemeanor level possession crime. And that generated a whole bunch of different calibrations. But the bottom line was, then they ended up breaking out marijuana from marijuana product, a term really to define hashish. So as to marijuana, which is defined as the leaves, the stems, and the flowers, possession of less than an ounce is a violation. Possession of more than an ounce but less than 4 ounces is a Class B misdemeanor. And then possession of more than 4 ounces is the C felony, with the technical fix in there. With respect to marijuana product, hashish, possession of less than a 1/4 ounce is a B misdemeanor. Possession of more than a 1/4 ounce is a C felony. There are a number of states that do recognize middle tier misdemeanor possession crimes for marijuana. The bulk of the cost savings from doing this comes from the Public Defender Services Commission savings, because it's less, they reimburse attorneys less for defending misdemeanors than they do for felonies. And also, there's just residual cost savings down the road because they don't have to grand jury cases and bring officers in off of patrol and all that good stuff. So with the cost savings, again, there's immediate, in the current biennium, cost savings projected at $2.43 million, and for next biennium it would be $3.88 million. We do agree with the amendment. What happened, currently, possession of less than an ounce is an unclassified violation with a presumptive fine of $650. I don't really know why the bill, and I wasn't the architect for a lot of this, but I don't really know why they chose to classify the violation as a Class B violation, but in doing that, the presumptive fine was $240, which created the revenue hit. So the amendment, as I understand it, simply creates the presumptive fine back again to $650, so there shouldn't be any revenue impact. Happy to answer any questions.
My name is Pete Kramer. I'm a resident of Kaiser. I'm a medical patient. I agree with Ms. here. Thank you for letting us hear this. I get to tape this for our community television station, Channel 23, to let the public see what you good people are doing here.
Okay. Well, thank you for your service. Thank you. Okay, thank you very much. Oh, I'm sorry, go ahead.
Well, no, I just want to say something afterwards before you close out.
Okay, now's the time.
Mr. Chair, we moved House Bill 3371 down the revenue from this committee. It's still sitting down there. We currently have House Bill 3460 that's down in Ways and Means and Subcommittee down there in Human Services. This Wednesday, Senate Bill 281 is going to be heard on the House side for health care, and 281 is the bill that Senator Boquist introduced that deals with traumatic stress syndrome. There is an amendment in that would create a work group that these other two bills I had mentioned, including this one here, this is bad timing right now with everything else that's in the building right now. We're dealing with marijuana. And I really do think, taking into consideration what's going on with Washington and Colorado, not knowing where the feds are going yet at this point right now, but the work group makes more sense, and that's what the amendment to 281 is all about. Otherwise, if we're going to do anything at all with this bill here, it should be something addressed in the Committee on Public Safety.
Okay, thank you.
I strongly echo the comments of my colleague. I would add to the list House Bills 3194, 3195, 1359, all of which do rather comprehensive and sensible marijuana reform. I even liked some of the other bills, and there are others too. This is one of many. Some of the other bills, for example, included in the concept articulating the number of plants that would be illegal and providing further guidance along those lines. So thank you for the attention to the issue. But that's where I'm coming down on this point.
Chair Barker, members of the committee, I would ask Representative Olson, Representative Hicks to consider, at least as to this bill, our original core function on our bill was to clean up the technical disparity with the calibration of marijuana crimes being inconsistent with its current status as a Schedule II drug. So right now, when the crime of marijuana was broken out, the breakout criminal crimes for delivery and possession of marijuana was back when it was a Schedule II drug. It is now a Schedule I drug. It is now a Schedule II drug. And so there's a lack of disparity here between its the exposure on crimes to its schedule count. It's impactful. If you're convicted of more than an ounce of marijuana, it's a B felony, and you will never get that expunged because B felonies are not expungible. So if you feel that this policy fix with respect to the misdemeanor count merits further discussion in a grand global sense, that would be one thing. What I would ask you, in its original form, this did one thing and one thing only, is correct that technical disparity, and we would hope that this committee might see good cause to move forward with at least that.
Chair, Mr. Wilson, I would think that that's a legitimate point. We are actively looking at, in the Public Safety Committee, one of the elements of the final bill may well be something on presumptive probation for marijuana offenses. So I think to the extent we're talking about something larger, it does make sense to do it in that committee. But at a minimum, I think the issue you're describing should be fixed this session.
Thank you.
Mhm.
Close the hearing on Senate Bill 40. And open the hearing on Senate Bill 186A.
We've had testimony on this one. This is, Mr. Chair, members of the committee, Senate Bill 186A. We've already heard testimony on this. This would be the warrant.
Post-traumatic stress disorder is the definition of debilitating medical condition for the purpose of authorizing medical use of marijuana.
Calls on here. We have about 20 minutes to do this. I'm going to ask you to all keep your testimony to 2 minutes, and we'll get everybody in. And Representative Olson, I see you back there. Why don't we start with these two gentlemen and then Representative Olson in the first panel.
We had anticipated having the witnesses who are testifying by phone testify after the first panel.
After the first panel?
Yes, sir.
Okay. Let's start with the two of you, and then is Representative Olson still here?
I don't know that he is. We have a third person for the first panel as well. If,
Yeah,
you
I
want to
know.
hear that.
No, I'd like to hear Representative Olson if he's here. Apparently not. Okay, bring your third person up. 2 minutes. Go ahead, please.
Thank you, Mr. Chair, committee.
Hi. I am just wrapping up with the patient. Can I call you back in about 1 minute?
No, we'll call you back in about 5 minutes. Please go ahead.
Thank you, Mr. Chair, committee. My name is Todd Delato. I serve as chair of the Oregon Health Authority's Advisory Committee on Medical Marijuana, which unanimously supports the addition of PTSD to the list of qualifying conditions for the Oregon Medical Marijuana Act. I'm also a horticultural scientist and public policy consultant specializing in medicinal cannabis. I'm a constituent of Senator Boquist, who sponsored this bill on my behalf. And we're trying to be brief here, but I do encourage the committee to, if you have any doubts about this bill, to look at the to listen to the audio testimony from February 7th Senate Healthcare Committee hearing. There's a wealth of information from some of the nation's top medical experts and some compelling testimony from PTSD sufferers as well. I'm going to explain why we're doing this by statute. The Oregon Health Authority is charged to adopt rules for evaluating petitions for particular diseases or conditions to be included among those that qualify as debilitating medical conditions under the Oregon Medical Marijuana Act. The rules that were promulgated involved convening an expert panel to review the petition and make recommendations to the department regarding approval and denial. Unfortunately, these rules have proven to be inadequate for ensuring a fair review and decision-making process because of a lack of protection for bias, prejudice, and conflict of interest, and the lack of a requirement for the decision to be based upon objective scientific evidence. These serious flaws amount to a review process that fails to ensure petitions to add debilitating medical conditions will be reviewed fairly. This was manifested on 2 occasions in 2000 and 2009, which Mr. Berger will follow up with and give you details about how that went down.
I'll give you a couple more minutes because you'll lead off, but everybody else will have 2 minutes.
Sure. And in June 2012, the Public Health Division was finally convinced that these flaws necessitated an overhaul of the review process. Thus, a Rules Advisory Committee was convened, which I was appointed to recommend changes to the administrative rules, with the goals of establishing protections against bias, prejudice, conflict of interest, which was not met, to enhance accountability and transparency, which was partially met, establishing clear criteria for decision making, establishing a fair selection criteria of experts, and to streamline the process for greater efficiency. The Oregon Health Authority's Advisory Committee on Medical Marijuana voted unanimously to support these goals, as well as the Rules Advisory Committee and most people who testified during the public comment period. In the finalized text, unfortunately, only one goal was fully met, and that was streamlining efficiency. Some of them were partially met, but the most important goal, to establish protections against bias, prejudice, and conflict of interest, was not met. And because this new rule will not ensure the objective review of future petitions to add debilitating medical conditions, and due to the bias that existed in the prior 2 petition processes, patients who suffer from PTSD and other debilitating conditions are still unable to rely upon the administrative process to consider their condition fairly. Therefore, the addition of debilitating conditions by statute is the only remaining way to ensure people suffering from medical conditions that are safely and effectively treated with medicinal cannabis can be protected for their use of medicinal cannabis. I'm going to speak briefly to the -5 amendments that Representative Olson will be presenting. I oppose those amendments as much as I support an intelligent approaches to cannabis policy reform. I don't feel it's appropriate to add that to this bill for a number of reasons, and largely because sure. And anyway, so I'm just urging you to please support 281 with a due pass recommendation without amendments, so that Oregon can become a place where returning combat veterans and others suffering from serious trauma can feel more safe and protected here at home in Oregon. Thank you. I'm here happy to be available for questions.
Thank you. Next.
Chair Greenlick, members of the committee, my name is Leland Berger. I'm a lawyer. I've been practicing for 30 years. I represent patients and their providers statewide. I live and work in Representative Frederick and Senator Shields' district. The Medical Marijuana Act includes a provision, as Mr. Delato's testified to, where conditions can be added administratively, and if I were a legislator, I'd want to know how come this is in front of the legislature, and that's what I want to tell you about, is how we exhausted our remedies as quickly as I possibly can, but it's a long and tortured story.
It's a long and tortured story. You can talk all you want, but we're going to quit this hearing.
I understand. I'm talking.
Anytime you take, and the long and tortured story is going to take away somebody.
I understand. I'll talk quickly. Thank you, Chair Greenlick. Chair Greenlick, the bill passed the people passed the OMA in 1998. The first cards were issued in May of '99. In early '99, the Rules Advisory Committee created rules for adding new conditions. 1999-2000, about 20 petitions were filed, including petitions for PTSD, consolidated so-called hearings, which were held in private with secret evidence, held with unanimous agreement to add anxiety. The Department of Human Services instead added adult Alzheimer's, which ultimately, after Speaker Minnis was voted out of office, was codified. On March 28, 2005, a registered nurse who worked as a psychiatric nurse named Ed Glick filed a petition to convene the advisory panel for the purpose of considering the inclusion of several conditions based on a study he had done at a place called the Compassion Center in Eugene. Dr. Grant Higginson on December 13, 2005 summarily denied it. The petition, the cause and pretense was that it was frivolous. Nurse Glick filed a petition in the Benton County Circuit Court where he lives, and Dr. Higginson offered to rescind the summary denial Nurse Glick rejected this proposal because of how unfair DHS's procedures were in 2000. I met with Leonie Reeves, who's an Assistant Attorney General, now the Governor's Counsel, and we discussed a more fair procedure. On January 26, 2009, at Nurse Glick's behalf, I filed a renewed petition to add 6 psychiatric conditions, including PTSD. Public hearings were held on 3 days in July and August of 2009, based on the rules that we had come up with. The panel was unfair. The way that Dr. Higginson structured it is he would appoint 3 marijuana prohibitionists and 3 people with knowledge of cannabis therapeutics, and so he ultimately would make the decision because the panel would split inevitably, which they did. And his recommendation was that the OMMP consider initiating a legislative concept for the 2011 session to allow research on medical marijuana for PTSD, which of course DHS never followed up with. The final report was issued October 2009. Dr. Cohn issued a notice of intent to deny. Nurse Glick sought administrative review, which was once the administrative judge decided he had jurisdiction and limited the scope of the hearing to whether they abused its discretion, he of course subsequently affirmed the decision. Nurse Glick had the right to appeal that to the Court of Appeals, but that would be futile, so we did not. We've exhausted all other remedies other than a legislative solution. And on his behalf, on behalf of all Oregonians, it isn't Chair Greenlick and members of the committee that there aren't patients who are enrolled in the medical marijuana program who are using it for PTSD. They're lucky enough to have other qualifying conditions, but there are patients, including, but not exclusively, combat veterans.
I ask you to wrap up.
I am wrapping up. Thank you. I'm sorry. I'm asking on behalf of combat veterans and others who don't suffer from listed debilitating medical conditions to be able to get the protection of the Medical Marijuana Act so they can't be arrested, prosecuted, have their property forfeited, and be imprisoned for their therapeutic use of medical cannabis to treat PTSD, that this committee send this to the House with a due pass recommendation and pass it out of the Senate, and we ask that this committee move the bill forward. I appreciate your patience with me. Thank you, Chair Greenlight.
Chairman Greenlight, members of the committee, my name is Anthony Taylor, and I'm the director of Compassionate Oregon, and I am in a Representative Boquist district and Representative Widener. I'm sorry, Senator Boquist and Representative Widener district. I'm going to defer my testimony to call-in testimony, so that time is short. So I'm going to defer.
Okay. You want two call-ins? We'll do that, and then we'll do Representative Olson. Thank you very much. I'm going to try and get everybody to have a little chance at this.
Mr. Chair, while he's dialing out, I have a question for the attorney. On page 2, line 3, or line 6, it adds distribution to the current law. Is there a reason why we had to add distribution to it?
Representative Widener, Chair Greenlight, I don't have the bill in front of me. I'm not...
Just medical use marijuana means production, possession, and delivery, and then we added distribution or administration of marijuana.
I can tell you that Representative Widener, Chair Greenlight, that's something that happened by Legislative Council, and it wasn't something that we had requested as part of this. Apparently, Legislative Council thought it was necessary. I'm primarily a criminal lawyer. In Oregon, there is no separate crime for distribution. There's a law for delivery, which is the actual or attempted transfer of controlled substances.
Okay, please go ahead and introduce yourself.
This is Brian Crum. I'm a psychiatric nurse practitioner in Albuquerque, New Mexico.
Please go with your testimony. We'll try and hold it around 2 minutes.
Okay. As I said, I'm a psychiatric nurse practitioner in Albuquerque, New Mexico. I helped to draft the medical cannabis law we have here, and I helped to get PTSD added as an indication to our medical cannabis program. I currently manage probably somewhere close to 1,000 patients in our medical cannabis program who have PTSD. It has proven to be not only the most effective medication for treating PTSD, but it's the only medication that effectively treats all three of the major symptom clusters we see with PTSD. Dysfunction of we have a very complex system of receptors in our bodies called cannabinoid receptors. We also produce our own cannabinoids to help stimulate those receptors called endocannabinoids. We actually have new evidence that just was released yesterday. A new study came out it was published in the journal Molecular Psychiatry. The title of the article is Elevated Brain Cannabinoid CB1 Receptor Availability and Post-Traumatic Stress Disorder, a positron emission tomography study. And what they found in this study, they looked at patients who are diagnosed with PTSD, and they find very real changes in the way the endocannabinoid functions in PTSD patients. They suggest that cannabis may be one of the most effective treatments for treating PTSD, cannabinoid-based medicines. In my own practice, I have found cannabis to be very consistently beneficial in helping with PTSD symptoms. A lot of my patients still need to have other medication treatment, but I find that cannabis is better tolerated and more consistently beneficial than any other medication available. The only FDA-approved medications that we have available for treating PTSD are Zoloft and Paxil, which are highly ineffective and in many cases actually make patients more suicidal. We know from previous brain studies that there are dysfunctions in the endocannabinoid system that are involved in suicidal behavior. Suicide is something that's very common among PTSD patients, and I have many patients who have reported that cannabis is the only medication that has effectively alleviated chronic suicidality that they have carried through many years of their lives. As I said, this is the safest and by far the most effective medication available for treating PTSD. I do have a paper that I have pending publication. It has been accepted in the practice journal for my field, which is called the Nurse Practitioner, and it is due to be released sometime within the next few months. And I'm very familiar with the neurobiological processes involved in PTSD. As I said, I have over 1,000 patients, or somewhere close to 1,000 patients that I manage right now for PTSD in the medical cannabis program, and I found it to be very effective. I would strongly encourage the legislature of Oregon to pass or to approve PTSD as an indication for your program there. And I'm happy to answer any questions if anybody has any questions for me.
We appreciate your testimony. Thank you. Are there any questions? Okay, thank you very much. Well, let's get, can we excuse you and let's get Representative Olson to make the next one. Thank you very much, guys. Ms. Taylor, thanks for Representative Olson.
Get this all squared away for you, sir. It's going to be short.
Yes, sir.
You've been listening.
That's right. Representative Green, or Chair Greenlight and committee members, my name is Andy Olson. I'm a member of the House and represent the Albany area. But I would just like to have you consider the -5 amendments to Senate Bill 281. And the reasoning behind that is I have been involved with a number of work groups over the last few years dealing with medical marijuana. And I mean, first of all, I just want to quickly tell you that I am a big supporter of the Oregon Medical Marijuana Act and the program itself. But I understand that there's some serious abuse that's going on right now, the last few years here in the state. I also know that there are a lot of patients out there that need to have the medical marijuana accessible to them, and I want to create that avenue. But we have two bills right now that we're dealing with. That one of those bills that you moved to Ways and Means, which is House Bill 3460, that essentially legalizes it for recreational use. And then the other one that came out of my committee in Judiciary a few weeks back and that's House Bill 3371, which is down in revenue. And that deals with taxation and creates dispensaries. The only reason that I would like to have you do this and think and consider adding the -5s to this bill right now is to create a work group. My reasoning behind that is right now we don't know where the federal government's going to be and where they're going to land eventually with what's happening in Washington and Colorado. I would like to be able to learn from them and have a work group and then move forward. When 2014 comes, we would have a bill that would work extremely well for Oregon and hit the ground running and come to 2014 session. That's the reason why I come forth with this right now. And I just leave it to you.
Why do we need a bill for this? Why don't we just do a work group? We're trying between this committee and the, say, the judiciary.
Well, you know, I had that discussion with the speaker too last week regarding that too, and you could do a work group, but I guess the reasoning behind it is that this clearly gives direction from the legislators anyways, that we are interested. We have some concern with the other bills that are on the table right now here in this building, and we feel at this point right now this might be the better path to travel.
Thank you. Are there any questions?
Thank you, Mr. Chair. Just a clarification for the record, I don't think House Bill 3460 legalized marijuana for recreational use. Is that what you thought?
3460?
Yeah.
Yes.
It didn't, it was around distribution for medical marijuana. It was setting up a distribution system for medical marijuana. So I don't think anyone on this committee voted for recreational use. Doesn't mean that people might not in the future, but yeah.
Well, the argument was in fact that it gives you a place to use the excess marijuana that's grown, so it doesn't get into the black market. It's the
Okay.
theory.
For the record, I'm supportive of a work group. Just wanted to make sure if anyone's listening out there.
Okay.
Yeah, I think I am too. Whether we pass this or not, I think we should have a work group between us and judiciary to get ready for the January session to do the kind of things you're talking about.
We're good. Thank you, Mr. Chair.
Thank you, sir. Thanks. Okay, one more phone call, and who will be after that?
Charles McPherson, Neil Feldman, and Don Esch.
Okay. Why don't you guys come up while we listen to the phone call? You may want to move over a little. Hi, this is House Committee on Healthcare. If you'd introduce yourself and give your testimony, please.
Yes, sir. Michael Krawitz. I am Executive Director of Veterans for Medical Cannabis Access.
And if you please try and keep it to about 2 minutes, we're running very late.
Yes, I'll do my best.
Thank you. Go for it.
As I said, I'm Executive Director of Veterans for Medical Cannabis Access. I am a disabled United States Air Force veteran myself, and I thank you for allowing me to speak in support of Senate Bill 281. I was lucky enough, after about 10 years of working on pain management policy within the VA, to be in a position to actually negotiate with the VA on the first ever medical marijuana policy that was passed in the VA in 2010, allowing for veterans to use medical marijuana. They did so after being connected with the California Medical Cannabis Research Group and their double-blind placebo-based studies, some of them done at VA hospitals. And that policy, while it specifically allows veterans to use medical marijuana, it also specifically prohibits doctors at the VA from bringing the subject up or writing recommendations. So they really do lean on you. The VA is leaning on the state to take the lead on medical marijuana issues and then pass them back to the VA, where they then have a policy in place to handle the medical records and to further counsel the patient, assist in many ways. I think it's important to point out that my colleague Brian Crump talked about some of the medications for post-traumatic stress approved and used off-label. It's important to recognize that the Army Surgeon General recently came out with a memo saying that these drugs, even the best ones that are actually approved, aren't very good. The ones that aren't approved aren't worth the risk, and that's pretty much a direct quote. I think it's also important to recognize that not allowing post-traumatic stress as a condition listed in the state program while allowing for pain, which pain is actually a common symptom of post-traumatic stress, while it rightfully causes the pain indication to be overloaded, raises red flags for law enforcement. You've heard that before. I want to add that it also creates a stigma and adds to the stigma and helps to hurt those that are trying to get veterans in to seek treatment, as I do. We're trying to reduce the stigma and tell them that it's a regular medical condition to be treated. And what are you telling them by your not allowing it to be approved as a condition with overwhelming evidence? Absolutely. The Fox News that Brian Crump talked about, the headline of the news show was the first ever evidence-based treatment for post-traumatic stress. And they're doing that for brain scans where they show this deficit in cannabinoids that is being filled by cannabis and then allowing the veteran to sleep, get rid of the nightmares so they can get through the night, reduce some of the hypervigilance. It's a nightmare state that you live in with post-traumatic stress. And we know as vets that it works. But I'll tell you, what, as a national advocate, what really sways me more even is the families and the friends of the veteran that tell me that it improves their life. So, we need you to take a lead. Sorry, I'm kind of emotional. It's just, I don't suffer from post-traumatic stress myself, but I read every day of the loss of those fellow vets who died because they can't get the help they need. And that's just unacceptable. Cannabis helps. It helps. Please do what you can to put it in the hands of those who need it and not have them face jail for using a medicine that gives them some rest. Thank you so much.
Thank you very much for your testimony. We appreciate it.
May I begin, sir?
Please.
My name is Captain Eugene F. Ebersole. I was a U.S. Navy Judge Advocate General for 30 years. I was also a U.S. Army soldier and from 1968 to 1970 and served the tour of Vietnam in Cu Chi and Lai Kay. After I became a lawyer, after I got out of the Navy, I became, in 1989, Assistant Attorney General to David Frohnmeyer, who worked for the Oregon Department of Justice for 21 years. I've suffered from PTSD since I got back from Vietnam, and it took me until after I came back from Iraq in December of 2009 before I was a man enough, and like alcoholism, there's a stigma attached to being a PTSD vet. People think we're crazy. And it worked pretty well for me as a lawyer because I was pretty aggressive and I was very successful. Representative Ken I spent a lot of time in these hallowed halls passing a lot of legislation, 20 years in consumer protection, and a year after I got back from Iraq in the criminal justice section at the Department of Justice's worst stint of history. But I come to you today because I am also carrying a second shadow over me that I sometimes fear because of being raised in the shadow of reefer madness and inappropriate attitudes towards cannabis. And that is that when I got out of the Oregon Department of Justice and had to go from my state health insurance, I had to rely upon TRICARE. I was lucky enough to get a doctor who was an ex-Air Force flight surgeon with multiple tours of combat in Afghanistan treating veterans, or treating soldiers. And she was the one that recommended that I get a cannabis certification. I'm 100% disabled. I'm blessed that I don't have the disabilities that would stop me from participating in what appears to be a normal life. But I can tell you that I have a great deal of help from having the ability to have medical marijuana at my disposition, because the VA, we're really lucky in the Northwest. The Oregon VA can't be beat, and the feds have done a great job handling the caseload here. But we have a lot of veterans coming home, and I want to make sure that you don't get stuck in the quagmire, as I've learned in this house, that If you attach this bill, this simple, very simple piece of legislation to some other thing and put it in a working group and send it to another place, it can vanish very easily. And I don't want that to happen. I want you to just take this very simple piece of legislation and say, PTSD, medical marijuana, it's a good match. It works. Please do a do pass. Take all that other stuff and let it carry with the legalization for the bigger bills. This is a small thing to help vets. Thank you.
Mr. Chairman, my name is Don Esch. I'm a combat veteran from Vietnam, and I've been suffering for 40 years. This is hard for me to talk about this. I get kind of upset, but I suffered for 40 years. With nightmares, hypervigilance, tough time relationships, with PTSD. You suffer in silence, you know, and there are many suicides now because of this PTSD. It's a tough way to live. I would wish this on anybody. I just urge you to pass SB 281 for the veterans and everyone that has PTSD. Please pass that. Thank you.
Thank you very much for your testimony. Yes, sir.
My name is Neil Feldman. I'm a resident of Salem. I'm in Representative Clem's district with Senator Courtney's. I am a Navy vet. I used to be not in the chair. I don't have PTSD myself, but I do know a lot of vets that do. I think that it's absolutely astounding and unconscionable that PTSD was not put on in the first place, but that also the DHS, then OHA, whatever they want to call themselves, has basically put every roadblock under the sun into doing this very simple thing. And I agree with the gentleman over here. It's a very simple bill. It's like I made a comment to Mr. Larson there that it was one page. You don't see that often. I'd really like it to stay that way. It's a good bill. It's a needed bill. I have friends of mine, like I said, who have PTSD. Many of them have attempted suicide. So far, luckily with me, nobody has succeeded. But it's ridiculous that the people that we owe the most to, our veterans, they're dying right now faster back home than they are in combat. And there's just no reason for that. But also, I have friends of mine who have PTSD, several of them from criminal acts against them, one of them from spousal abuse. And so I don't want to just limit it to veterans, but it should be available to everybody. Cannabis is extremely effective in treating PTSD. I am myself an Oregon medical marijuana patient for pain and various other issues, not PTSD, but it's always angered me anytime anybody that I know seeks to get on a on the OMP. What do they have? Oh, we have PTSD. Oh, that's not covered. Sorry, go away. Go get thrown in jail or something, because most of them end up treating them themselves anyway. But they go through the black market, lack of quality, lack of safety. I mean, not only from the medicine, but also just the situation is not very safe for them. And by doing this, they have to put their freedom and liberty at risk to have any sort of decent health. And I agree with the other person who testified earlier that pretty much most of the drugs are dangerous garbage and they do more harm than good. Most everyone I know that's taken any of them, Zoloft, Cymbalta, any of them, they end up becoming extremely suicidal. And when you're already suicidal at that point, it doesn't help. But thank you very much. I very strongly urge a upvote, no amendments, no nonsense, just a due pass to the floor. Thank you.
Did I miss somebody on the list? Nope. Good. Okay. Well, thank you. Thank you all.
Yeah, Charles McPherson was supposed to be here, but apparently he wasn't able to make it.
Let me, folks, we're going to work this Friday. would you let the rest of the folks who aren't here now know? And we'll have next Friday off, which will extend the weekend. I've already got approval for that, so.
The following Friday.
The following Friday, yeah. This Friday we'll work at a long, long agenda. A week from Friday we'll be off and we can announce both of those things, if you let the other folks know.
Okay.
I'm gonna close the public hearing on Senate Bill 281. If you all would let me know what your wishes are on this one, we'll carry it over to Friday, and please carry over a work session on 281 for this Friday. We're gonna have a really long agenda on Friday, the same kind of, too many people to testify. What we don't do, we'll carry over the following Monday, but let's try and do whatever we can. Work session, possible on this. Any comments, discussion? We are adjourned. Thank you all for your patience.
You want to say anything before I turn it off, Glenn?
Yes, good night.
Good night. God bless you all, every single one of you.